Welcome back, everyone. Good afternoon. Do we need to do a roll call, please?
This is David Bruggeman. I'm ready to take the roll.
Yes, thank you, Mr. Bruggeman.
As I call your name, please, as I call your name, please let us know that you're here. Dr. Mateki.
Yes, present.
Kitman Chan. Kitman Chan, are you here? Yongting Chen. Dr. Chen, are you here?
Yes.
Thank you.
Thank you.
Member Kim, are you here?
I'm here.
Great, thank you. Shudong Lee, are you present?
Yep, I'm here.
Great, thank you. Ruben Osorio, are you present?
Yes.
Thank you. Kitman Chan, are you with us today, this afternoon?
This is the moderator, Board Member Chan. If you are currently speaking, you are muted. And you'll want to click that microphone icon at the bottom of your WebEx screen.
Hi, this is Kitman Chan.
Thank you.
Thank you, sir. President Mateki, I show 6 board members present so that we can still have a quorum and we can proceed.
Thank you, Mr. Bruggeman. So let's move on to agenda item number 10, enforcement quarter number 3, fiscal year 20 to 21. Ms. Cricket Burgess, please.
Good afternoon, everybody. This is Cricket, and I'm the enforcement coordinator. I will be presenting to you the quarter 3 enforcement statistics. As you can see in this first graph here, it indicates that the board received 25 complaints. Each complaint is categorized by category, and then a couple of them are also broken down in subcategories. The first one is the unprofessional conduct, received 11. Broken down, we received misrepresentation as a doctor, there were 4. Misleading advertising, there was 1. There was some kind of issue with patient records, there were 2. Some sort of issue with office conduct, there were 2. And address change or failure to register their business addresses, there were 2. We received 1 unlicensed or unregistered complaint. Criminal charges or convictions, we received 4, and those are broken down between applicants and licensees. For the applicants, we received 0, and for licensees, we received 4. For sexual misconduct cases, we received 1. For fraud cases, we received 2. Non-jurisdictional cases that were received were 3. Cases of incompetence or gross negligence were 3. And the remaining cases, their categories, all were 0. The next chart that we have is the actual investigations that are broken down by category. In the third quarter, we actually initiated 28 investigations. These include both formal and informal investigations by DFI and our desk investigators. Total we have for pending investigations, we have 218. This again includes both desk and DFI investigations. And during the third quarter, we closed 33. I want to pause there. Does any board member have any questions at this point? Okay, moving on to the statistics report itself. For our complaint intake or performance measures 1, these are the complaints received as well as convictions and arrests. We had a total again of 24 complaints received. 4 of those were convictions or arrests, and again a total received were 28. The total intake cycle time for these cases to get them open and assigned was on an average of 4 days. The PM3 cycle time, the average number of days to complete the entire enforcement process from complaints investigated and not transmitted to the AG for formal discipline, which include intake, investigation, and case outcomes or non-AG formal discipline. All investigations closed was an average of 31 days. There was 31 cases closed. It was an average time frame of 423. The percent that reflects how many investigations that were closed in the respective time frames. We had 12 cases that were closed up to 90 days, 2 cases that were closed within 91 to 180 days, 5 cases that were closed 181 days to a year, 9 cases that were closed between 1 and 2 years. There are cases that were closed between 2 and 3, and 5 cases that were closed over 3 years. The average time frame in this next one reflects the length of time it took to process citations that were closed within the respective quarter. We served 2 citations, and on average days to close these particular cases, it took 1,062 days. We have a very small amount of citations that we issued, so this number, the average days to close, does get skewed sometimes by cases that are more complex and take us a lot longer to investigate before we can actually get them closed. So because we have so little cases that we work in this area and finalize the citations, that number can jump up quite a bit. So that's probably what happened with this case. PM4 is the cycle time discipline. It's the average number of days to close cases transmitted to the AG for formal disciplinary action. These include formal discipline and closures without formal discipline, for example, withdrawals and dismissals. The first chart, our target day is 540 days, and within the third quarter, we closed 1 case, and the cycle time to close this case was 1,681 days. Again, because we only have 1 case that we closed, the case that was actually closed is probably a more complex case that took much longer to investigate, or was at the Attorney General's office for a lot longer due to the complexity, so it took us longer to close it, which is why this cycle time jumped up. So the chart next to that is it has to do with disciplinary actions. You'll see that we had 2 cases that were initiated that we sent to the Attorney General's office for discipline. Currently, or as of Q3, we had 15 cases pending with the AG's office. We did not file any statement of issues, which are cases against applicants. We did file 1 accusation. We did not close any of the cases after it was transmitted. We had not revoked anybody. We did not receive any voluntary surrenders. We did have 1 go on probation. We did not have any license denials, public reprimands, and we did not close any without disciplinary action. The next graph shows how long it took, to close the cases that were already assigned for discipline. And you can see we only had 1 that we closed, and it took over 3 years to close it. Other legal actions by enforcement, PC-23 is ordered. We didn't have any, and we didn't order any or have any interim suspension order cases. And that concludes the enforcement report. If any board member has any questions, please let me know.
Are these complaints and investigation, is it kind of a similar from other healthcare professional reports, or I'm sure that you cannot share by numbers because they all have different numbers, but in terms of percentage-wise, mostly I see from unprofessional conduct. Is that the new the trend? Is this trend is uniform with other healthcare professions?
I would say that the average for smaller boards is probably similar to this. Boards that have a larger population of licensees, such as maybe medical doctors or registered nurses, these numbers are going to be much higher. But due to the fact that our population is much lower, I have a feeling this is more of the consistent with the smaller boards. Does that answer your question?
Yeah, thank you very much.
You're welcome.
I see Vice President Chen has his hand raised.
Yeah, this is Kim Chen. I had a question regarding to the unprofessional conduct. And right now we by category. The first one, the misrepresentation of doctor. In this quarter had 4 cases. I think the first time I saw that, okay? And the previous quarter and our previous couple years, we don't have this kind of that many cases. I just wondering why this quarter had incurred 4. Is that really this 4 cases very similar? They mix up the title, or they make the public believe they are doctor title.
Typically, these cases, when they come in, it's because a patient may have seen an acupuncturist and somebody in the office is calling him maybe doctor, or a member of the public is searching the business online, and somewhere in the write-up on their web page or whatnot, it says Dr. So-and-so. These are all typical cases or scenarios that we actually open this to determine actually whether or not they are doctor, have received the PhD, to determine whether or not, if they are misleading the public. We do find that sometimes with the foreign language, a lot of patients or even staff members, we find on like Yelp reviews and whatnot that members of the public call them doctor, even though they aren't a doctor. And I believe that it's because that they're helping the person, they're helping them with their ailments, so they typically just call them doctor. So the outcome of these cases can have different, they can be different outcomes, and it could just be because we don't have the PhD or doctorate degree on file, so the members of the public don't realize that they truly can call themselves Dr. So-and-so. We don't get these that often. They're not that common. If we get complaints, there's more than one allegation involved in the complaint. Say, for example, if it's a sexual misconduct case, but another violation or allegation that's within that case is this person is calling themselves a doctor, we don't categorize it as an unprofessional case with a misrepresentation of doctor. We take the more egregious category to categorize the complaint. So not all of these categories typically capture the most egregious violation of a complaint that's submitted that may actually have multiple little violations in it as well.
I see. So how do the public, in order to protect the public, how do the public distinguish who is a PhD, who is not? Because the board had some kind of notation or information tell the public how do they distinguish who's cannot call them a doctor or some kind of things, and let the public knows, because right now is that if people go to the acupuncture clinic and they treat everybody as a doctor, that is really misleading, and really had in a dangerous situation, is not protecting the public. So I just had a comment: how does the board take some action on that?
I can address that question, Vice President Chan. The board does not go out to seek, so we're not perusing the websites or going out to clinics, because we don't have that inspection authority, without it starting with a complaint first. then we have the authority to either do a desk investigation or request a formal investigation with the Division of Investigation. Now, in terms of educating the public, yes, we see this even happening at board meetings where members of the public will call some of our professional members who may have not had a doctorate in the whole history of the board, a doctor. And I hear it in acupuncture clinics as well. And, you know, it might be challenging for a licensee to continue to correct their patients on that. But yes, we don't go actively looking for this. We could look to, we did put out in partnership with the Office of Public Affairs, a description of the doctorate for acupuncture, as DCA was putting out an advisement to the public about know your professionals. And so even there, it's a challenge because there are different doctorate degrees available for acupuncturists. Going back to the OMD, Oriental Medicine Doctorate, that was offered for a brief period of time. And as we reviewed last year, the several first professional doctorates available, and the naming convention has not been settled on either. So we saw a number of various different styles. So it is a little confusing also within the profession, but we do act on it once we do receive the complaint. And we do discuss when these complaints come in by phone, or if someone's just calling our general line, we do go through this and do check the file of the licensee to see if there's a doctorate on file. Does that address your question?
Yeah. Okay. Thank you, Ben.
Certainly.
Thank you,
Any-
Vice President Chen. Yeah, I have a question here, Ms. Burgess. Following Vice President Chen regarding that the misrepresentation as a doctor, but here I see there is a category as a fraud. So, and there's a number actually in the investigation currently is around 46. Would you mind just, if you can not violate any rules, can you just maybe explain? Or maybe, let's see, the fraud maybe is a 10. I'm sorry, I read the number. So it's a 10. So what's the big difference in the fraud and then misrepresentation? Looks like it's a very different category here.
I'm sorry, which chart are you referencing?
So on the second page, there's an investigation there.
Okay.
So there is a fraud. Even in the first page, you mentioned about that. There's a unprofessional conduct category, and then there's a fraud category. So I'm just kind of trying to see as there's a 10 cases for the fraud, if I see it clear. Actually, it's a 46. So it is the number 46 is a pending for the fraud.
Correct. So you want to know what the difference is between unprofessional conduct and the fraud? Is that?
Yes, in a way, it's because, you know, the misrepresentation as a, you know, as a doctor. So I'm just trying to see for the public. So what does the fraud here represent?
So fraud typically here represents if there's fraudulent billing. That's mostly what these cases include. If it's just that somebody's misrepresenting themselves, at first we just categorize that as the unprofessional conduct. If for some reason we determine in the complaint that it may be somebody who is unlicensed and is representing themselves as a doctor and there is fraud involved, we can change the category in our system to from the misrepresentation to fraud. These numbers can change based on the information that we come across when we are actually doing the investigation. So because misrepresentation as a doctor may not necessarily be that they are doing it on purpose, we categorize it more of an unprofessional conduct at that point. If we determine that they're advertising it as doctor, but they've got fraud going on as well, we will change that to a fraud category because again, we use the more egregious violation within the complaint to categorize the complaints themselves. Does that answer the question, Amy?
Yes. Yes.
Okay.
Thank you. Thank you.
You're welcome.
Yeah. So any other board member comments? Anyone? Would you like to open to the public if there's no board member comments? So DCA moderator, could you please facilitate the public comments?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click that Q&A icon at the bottom right-hand corner of your WebEx screen. I'll go ahead and pause a moment to allow the public time to access the Q&A panel and submit their requests. It looks like we do have one individual who has requested public comment. Neil Miller, one moment while I get my timer up. You'll be given 3 minutes to speak and a 30-second warning. I am unmuting your microphone now.
My name is Neil Miller from Cal ATMA. I have a couple of comments. But one of the things that I would like to recommend is that we have some form of committee workshop to talk about enforcement. If you had an enforcement committee that could meet and simply sit down and answer questions and have a discussion, then it would be much easier for us to disseminate that type of information of what is misleading information, advertising. What is misrepresentation as a doctor? For instance, the OMD that Ben mentioned. We have members that have an OMD and some of them can't find the paperwork, and the school that issued that OMD is no longer in existence. So we'd like to bring that up as an issue at a workshop and then be able to answer that question rather than having somebody be brought up on charges of misrepresenting themselves as a doctor, where in fact they may be representing themselves, or they may have the right to call themselves a doctor. And some of the other issues, especially with patient records, since Cal ATMA has such a diverse membership with so many ESL members, we really want to be able to get that message across to some whose native language English isn't their first language. And all of the different things on here could be much better we could be much better at being proactive if we could ask questions and sit and actually have a discussion instead of hearing a report month after, every 3 months to hear a report and then ask questions or make public comment in 3 minutes, and then there's no interaction. So our comments just sort of go out on the wind, and then they show up in the minutes of next month's meeting, and then they go nowhere. So I guess I'll bring this up again for future agenda items, but it would be much better for the entire enforcement coordinator and the team if we can have a meeting with a public member and a board and a licensee member and some of the schools and some of the association representatives, so that we could be a lot better in this area of enforcement. And I'm very happy to say, having been watching this for so many years, this is the least amount of sexual misconduct cases that we have ever had. So I'm very happy that maybe we're getting the message across that you can't be doing certain things, and it's illegal. It's unprofessional conduct, and it makes us all look bad. So that's the end of my comment. Just that we should have some sort of meeting to be able to expand on the idea of enforcement and have some interaction so that we could be a bit more proactive. Thank you very much for the opportunity to speak.
All right, this is the moderator, and it appears there are no further requests for public comment. Would you like me to close the Q&A panel?
Yes, please. Thank you,
All right.
moderator.
The Q&A panel is now closed.
Thank you. So now let's move on to agenda item number 11. Legislative Report of 2021. Legislative Bills of Interest to the Board. Ms. Christine Brothers, Policy Coordinator, please.
Thank you, President Matecki. So first we'll cover the legislative calendar for 2021. And if you go to the second page, just to highlight some of the important dates here. June 4th, was the last day for each House to pass bills introduced in that House. And going forward, looking at July 14th, that's the last day for policy committees to meet and report on bills. Then we have about a month of summer recess. And August 27th, that will be the last day for fiscal committees to meet and report on bills. And we do have a board meeting scheduled on that date. So we'll be bringing the bills back for discussion and review because September 3rd is the last day to amend the bills on the floor. So any comments or amendments that we may have, we could submit that to the author in the legislature. September 10th is the last day for any bills to be passed, and then October 10th is the last day for the governor to sign or veto bills passed by the legislature. So moving on to the legislative report, it is quite long. We do have 17 bills to go over. Luckily, the majority of them have already been brought to the board for review. So we did have to cut our review off by May 28th. So the statuses that you're seeing, there's been more progress on these bills, but we are providing statuses as of May 28th, just so you're aware of that. So the first section, and as you'll see, the report looks kind of different. We've changed the format. So the first set of bills are bills that the board currently has a watch position on. So the first bill that we'll cover is AB 2. And this has not been amended since the board last looked at it. It's entitled Regulations, Legislative Review, Regulatory Reform, and it was authored by Fong. So just to provide a quick summary of the bill to refresh your memory, this bill would require each state agency to review its regulations, identify any regulations that are duplicative, overlapping, inconsistent, or out of date, revise the identified regulations, and report to the legislature and the governor. And then a year's time to do that. This bill is located in the Assembly Committee on Accountability and Administrative Review. It was held under submission by the Assembly Committee on Appropriations and did not make it out of its House of Origin, so it will likely not move for the remainder of this year. And again, there was a watch position on this bill. The other change that we are making is we're going to take public comment on all the bills at the end. So I will stop here, though, if there's any questions from board members before I move on. I'm not seeing any, so I'm going to move on to AB 29. And that's entitled State Bodies and authored by Cooper. Again, there have not been any amendments since a watch position was taken. It's located in the Assembly governmental organization. It was held under submission. So it did not make it out of the Assembly side. And again, it will most likely not be moving forward this year. Just to provide a brief summary of the bill, to refresh your memory, the bill would require that a state body providing written notice to someone who requests it must include in that notice all writings or materials provided for the meeting to a member of the state body. These writings or materials must be made available on the state body's website and to anyone who requests them on the same day that they are provided to members of the body or at least 72 hours in advance, whichever is earlier. If the state body does not comply with the above provisions, it cannot discuss those materials or act on an item pertaining to these materials at a meeting of that body. So, are there any questions on that one? Okay, I'm going to move to AB 54. This is entitled COVID-19 Emergency Order Violation, License Revocation, authored by Kylie. It was amended April 5th, and those amendments actually excluded DCA boards, and so we are no longer affected by this bill. It excluded, healing arts boards. And it also failed to pass out of Assembly Committee on Business and Professions, so not moving forward. But just to refresh your memory, this bill previously prohibited DCA, a board within DCA, and the Department of Alcoholic Beverage Control from revoking a license for failure to comply with any COVID-19 emergency orders, unless the board or department can prove that lack of compliance resulted in transmission of COVID-19. It was supposed to take effect immediately. But again, as stated, we are no longer affected by this bill. And there was a watch position on it at the time that we first brought it to the board. At this point, there's no impact and there's no need to change the board's position. And we'll just continue to keep an eye on it, but likely not to move. Any questions on that one? Okay, moving on to AB 107. This is entitled Licensure Veterans and Military Spouses, authored by Salas. This was pretty significantly amended on April 20th. It's currently with Assembly in the floor process. So when we first brought this bill back in March, at that point, the provisions that applied to the board, it provided reciprocity, and that it allowed veterans and military spouses to be granted a license based on possession of an acupuncture license in another state. So the amendments took that portion out, and I'm going to go over the provisions that, after the amendments, how it affects the board. And basically, it is implementing temporary licensure provisions. So just as context for understanding how this is changing existing law provides that temporary licenses shall expire 12 months after issuance. Upon issuance of an expedited license or upon denial of the application for expedited licensure by the board, whichever occurs first. That law currently applies to a handful of boards, not including the acupuncture board. So they're essentially expanding that law to be all licensing boards under DCA. So let me get into the full summary. The provisions of this bill would require all licensing boards under DCA to issue temporary licenses to applicants within 30 days who provide sufficient evidence that they are married to or in a domestic partnership or other legal union with an active duty member of the armed forces of the U.S. who is assigned to a duty station in California and are not grounds for denial based on the results of a criminal background check. This bill would provide that these temporary licenses shall expire 12 months after issuance, upon issuance of a standard license, upon issuance of a license by endorsement, or upon issuance of an expedited license, whichever occurs first. The bill would exempt a board from the bill's provisions that already has a process in place by which an out-of-state licensed applicant in good standing who is married to or in a domestic partnership or other legal union with an active duty member of the armed forces of the U.S. is able to receive expedited temporary authorization to practice while meeting state-specific requirements for a period of at least 1 year, or is able to receive an expedited license by endorsement with no additional requirements, superseding those for a temporary license. This bill would require, if necessary, a board to submit to DCA for approval draft regulations necessary to administer the provisions of the bill by June 15th, 2022. AB 107 would require DCA to prepare an annual report to the legislature containing specified information relating to the professional licensure of veterans, service members, and their spouses. So being that the impact to the board has changed, based upon the amendments. Let me go over that. After amendments were made on March 24th, the temporary license provisions in AB 107 now apply to the board. This is a new area of licensure for the board. Staff would need to establish procedures for temporary licenses, adapt existing computer systems, and obtain board approval. The board does not currently accept reciprocity with other states to grant an acupuncture license. Staff would need to develop procedures for processing licenses based upon reciprocity. There is an additional concern with the establishment of reciprocity. The California Acupuncture License Exam, or CAL, which is currently required for all applicants for licensure, addresses in part topics of practices, laws, and regulations specific to California. A recipient of a temporary license would likely have a gap in their understanding of the practice of acupuncture in California, unless they have previously taken the CAL. Providing a temporary license to practice acupuncture to applicants eligible for this pathway does not address the gap in knowledge, as these applicants will not meet the board's curriculum requirements. This poses a potential risk to public safety. This also creates a double standard that the legislature may not have intended by relaxing the board's requirements for these individuals alone, while requiring that all other applicants meet the 3,000-hour curriculum requirement. It is difficult to be certain how many applicants might apply under these new provisions. There's been interest from acupuncturists outside of California to have license reciprocity with California, which this bill would grant to the spouse or partner of a member of the military. Though the number is likely small, probably no more than 10. For context, the board received 2 applications for licensure in 2018-2019 and 2 applications for licensure in 2019-2020 under Business and Professions Code Section 115.5, which is the law that requires boards to expedite licensure for partners of an active duty member of the military. With AB 107 affecting the same population of applicants, it is expected that the pool of applicants who may seek temporary licensure under AB 107 will be approximately the same volume. Given the knowledge gap for temporary licensees described above, it is reasonable to anticipate some increased need for enforcement to address potential consumer complaints and/or violations by temporary licensees not familiar with California acupuncture laws and regulations. Just to go over also the fiscal impact, which is a newer section of our report to really highlight that sort of impact. Additional staff time would be required to develop a process for issuing temporary licenses, update regulations, adapt existing computer systems, and obtain board approval. Staff would also need to establish guidelines for enforcement of AB 107 provisions. It's estimated that this would take at least 15 hours for one office technician, 15 hours for one staff service analyst, 90 hours for one associate governmental program analyst, and 7 hours total for each board member at a public meeting. The slight increase in licenses based upon these very specific conditions would result in a minor increase in revenue. However, since given the business process workload and upfront IT costs needed to set up a new license, category, and status, the additional revenue may not offset those costs. With the relatively small number of additional licensees expected under the provisions of AB 107 and the estimated gap in California laws and regulations, there may be one additional complaint and/or investigation each year. On average, that would require 13 hours of an enforcement analyst, 40 hours of department investigation staff to handle the complaint and any necessary investigation, and additional attorney general costs if the case were to go for formal discipline. Section 2 of the bill would add data reporting requirements, and that would require roughly 1 hour of staff service analyst time to gather the necessary information from the licensing database. Staff estimates there would be an impact to IT related to AB 107, given the requirements to develop an infrastructure to process and issue temporary licenses in the board's database. And the board previously took a watch position. We don't have any requests or recommendation to change that based on the amendments, but wanted to make you aware of those changes and the impacts to the board. So are there any questions on that bill? Okay, moving on to AB 646. Department of Consumer Affairs Board's expunged convictions brought by Lowe. This was amended just slightly, not very significantly, on April 14th. This bill was passed out of Assembly Committee on Business and Professions and re-referred to Assembly Committee on Appropriations. It is a 2-year bill, so it may we may see it next year. And so just to update you on or not update you, but provide you the summary once again, AB 646 would require programs under the Department of Consumer Affairs that post information on its website about a revoked license due to a criminal conviction to post notification of an expungement within 90 days of the board receiving an expungement order related to the conviction for those who reapply for licensure or are relicensed. Additionally, the bill would require boards, on receiving an expungement order, to remove the initial posting on its website that the person's license was revoked, and information regarding arrests, charges, and convictions if the person is not currently licensed and does not reapply for licensure. The person seeking the change in either case must pay to the board a fee not to exceed the cost of administering the bill's provisions. So that last sentence there, that reflects the change when the amendments were made. The bill previously set the fee at $50, but based on the amendments, it now provides that the board can set the fee based upon the cost of administering the provisions. I'm not going to go into detail on the impacts to the board, but just wanted to highlight staff's concern regarding the public protection. Under the provisions of this bill, the disciplinary documents are removed when a person is not seeking relicensure or is not currently licensed. However, this person may possess a license in another state or another profession within the state. In this case, a consumer will not have access to the person's complete licensure history to make an informed decision. So that's just a consideration there. But there is no recommendation for the board to update their position. It's currently at a watch position. Any questions on that bill? Okay, moving on to AB 885. This is entitled Bagley-Keene Open Meeting Act, Teleconferencing, authored by Quirk. It was amended March 24th, and it's with the Assembly Committee on Governmental Operations. So I'm going to go over this bill based upon there were quite a few amendments. So I'm just going to summarize the bill as it is after the amendments. This bill would require a state body that conducts a meeting or proceeding by teleconference to make the portion that is required to be open to the public both audibly and visually observable. The bill would require a state body that elects to conduct a meeting or proceeding by teleconference to post an agenda at the designated primary physical meeting location in the notice of the meeting where members of the public may physically attend the meeting and participate. This bill would extend the above requirements of meetings of multi-member advisory bodies that are held by teleconference to meetings of all multi-member state bodies. The bill would further require any body that is to adjourn and reconvene a meeting on the same day to communicate how a member of the public may both audibly and visually observe the meeting. The impact to the board, the intention of this bill is to provide additional means other than just audio when meetings are being conducted remotely. Given the wide use of platforms like WebEx, Zoom, and Microsoft Teams that have cameras and other visual aids via screen sharing, holding open meetings where the public can observe audibly and visually should not be a problem. Furthermore, the board has been holding all its public meetings via teleconference through WebEx since June 2020. Providing more access to the public for participation and observation of the board conducting business is the goal of expanding the platform of the meetings. The only impacts of this bill are related to the fiscals, which I will get into. The fiscal impact of AB 885 on the board is expected to be in the areas of equipment and training expenses for the board members. Expenses related to meeting notices and additional bandwidth are expected to be covered within already existing media expenditures. AB 885 would require board members who participate remotely to be both audibly and visually observable. For board members to be visually observable, staff will need to provide them with computing devices with necessary software licenses and cameras so that members can be observed while participating remotely. Staff anticipates spending $17,500 for this equipment, or $2,500 per device for 7 board members. The members would need to be trained in DCA and State of California information security practices. This would be a total of 14 hours of board member time, 2 hours per board member plus expenses. And the average expenses would be $500 airfare, and then we costed out the rest of the trip expenses that you can see there, which would total $5,047 for all 7 board members. The board previously took a watch position, and based on the amendments, we don't recommend any kind of change, but just wanted to make you aware of the changes and the bill's provisions. Any questions on that? Okay. AB 1236, Healing Arts Licensees Data Collection, authored by Ting. This was amended on April 29th, and it's with assembly and floor process. And the summary of this bill is that it would repeal the existing provisions requiring boards to collect and report specific demographic information, and would instead require all boards that oversee healing arts licensees to collect at the time of electronic application for a license and license renewal, or at least biennially, specified demographic information, and to post the information on the websites that they each maintain. Effective July 1st, 2022, this bill would require each board or the DCA on its behalf to provide the information annually in aggregate form to the Office of Statewide Health Planning and Development. So the amendment to this bill was really minor. As part of the demographic information that's listed out in the bill, it did add disability status for the board to collect that. So that's really all that's different since you last looked at it. So I won't go over the impacts of the bill. And again, the board did have a watch position on that. Any question on that one? Okay. So the next section are some bills that the board has also previously seen, but these are bills with an opposed position. The first bill is AB 339, Local Government Open and Public Meetings, brought by Lee. It was amended on May 4th. And based on the amendments, the bill no longer affects the board because it did remove provisions related to the Bagley-Keene Open Meeting Act. So instead, the bill only affects local government open and public meetings. This bill is in assembly floor process, and again, because it no longer affects us, I won't go over the details of the bill or the impacts, as there are no impacts, being that it no longer affects us. Because the board previously had an opposed position, we are recommending that it take a no position, but there is no vote necessary. It's our understanding that the legislature will see that the bill no longer affects the board, and so they will know that the prior position is no longer relevant. So, any questions on that bill? All right, moving along. AB 918, Acupuncture Licensure Examination, authored by Quirk Silva. The board reviewed this bill in March, and there haven't been any amendments since that time. There hasn't been a lot of movement on this bill. It's located in the Assembly Committee on Business and Professions. It was converted to a two-year bill, so it won't be moving for the remainder of this year, but we will likely see it again next year. And for anybody who doesn't remember, this bill would require applicants to obtain a passing score on one or more examinations administered by the National Certification Commission for Acupuncture and Oriental Medicine, as determined by the board based on the skills, standards, and knowledge required for licensure pursuant to the Act. And we went through the impacts at our March meeting, and nothing has changed. And again, the board does have an opposed position on this bill. And are there any questions on that bill? Okay. Moving to AB 1386, license fees, military partners and spouses, brought by Cunningham. I think there's like 3 different bills related to the military community. So this is, I believe, the second one that I'm going over. It was amended on April 28th. It was held under suspense on May 20th by Assembly Committee on Appropriations. So this probably won't be moving any further this year. And just to provide some context to understanding what the bill is doing based on existing law. Existing law requires a board to expedite the licensure process for an applicant who holds a current license in another jurisdiction in the same profession or vocation and provides evidence that they are married to or in a domestic partnership or other legal union with an active duty member of the armed forces of the United States who is assigned to a duty station in the state under official active duty military orders. So the board currently does this and expedites that process. This bill would prohibit a board from charging an initial application fee or an initial license issuance fee to an applicant who meets these expedited licensing requirements. This bill would also prohibit a board from charging an initial examination fee to an applicant who meets the expedited licensing requirements if the examination is administered by the board. And that last sentence are the new amendments that occurred April 28th. So the impact to the board, it is similar to AB 107 that I went over earlier in its approach to providing more ease and convenience for military families when relocations occur for the retainment of one's career. The board receives very few license applications from the military community, military spouses specifically. Last year, the board received 2 applications. In the previous year, the board received 1. Although the impact to the board is not estimated to be significant, this kind of legislation may set a precedence for other communities to seek being pardoned from licensing fees. The board is special funded by its licensing fees, so the preservation of its fees is necessary to support and sustain the functions of the board. And we did have a little more to provide on the fiscal impact that we didn't go over in our March meeting. So based upon the board's history of low applicants affected by this bill, the board expects a revenue loss of approximately $4,900 annually if the provisions of AB 1386 are enacted into law. The board uses Connect and CAS as its database system, so both programs would need to be updated to record when an applicant qualifies for an initial fee waiver under BUPC 115.5. This will allow for easy statistical reporting on this in the future. The exact IT impact related to AB 1386 is undetermined at this time. Staff also estimates that regulations will need to be passed to incorporate the information and instructions related to the waiver of initial license fees for military spouses through the board's initial license application. And being that the amendments weren't too significant, it does not affect staff's recommendation to the board's current position of opposed, so no changes there. Any questions on this bill? Okay. Moving on to SB 772, Professions and Vocations, Citations, Minor Violations, CHOA BOG. This has not been amended since we brought it to the board. So I'll go over the status and a quick summary of the bill. The second hearing was set for April 19th, but it was canceled at the request of the author. It's currently located in the Senate Committee on Business, Professions, and Economic Development. It is a 2-year bill, so it's not going to be moving forward this year, but we may see it next year. And just to refresh your memory, this bill would prohibit the assessment of an administrative fine for a minor violation and would specify that a violation shall be considered minor if it meets specified conditions, including that the violation did not pose a serious health or safety threat and there is no evidence that the violation was willful. I just wanted to highlight the main concerns with this bill. The main concern is related to the fiscal impact and that the board would see a loss in revenues and fines annually. And it also removes the board's flexibility and discretion when addressing violations based upon the merits of a case, and that's the real concern there. And that's why staff had recommended an opposed position, and the board did take that position last board meeting. So nothing further to go over. Any questions on that bill? Okay, so the next section are brand new bills that the board has not reviewed yet. So these are bills that we're bringing for your consideration. I do want to point out that a new change or policy clarification: when staff has a recommendation for a watch position, if the board agrees with that, there is no, it is not necessary to make a motion and vote to take a watch position. We will just go ahead, staff will go ahead and start watching that bill. However, if there's a staff recommendation for support or oppose, we do have a recommended motion that you'll see. So the first bill that we're reviewing is AB 810, Healing Arts Reports Claims Against Licensees. It was authored by Flora. There haven't been any amendments since it was first introduced in February, but everything's new to us because we haven't reviewed this yet. It's with Assembly Committee on Business and Professions. And let me go into the summary of the bill. The relevant portion of this bill affecting the board raises the minimum fine from $50 to $100 for the failure of a licensee, claimant, or their counsel to report a settlement, judgment, or arbitration award over $3,000 of a claim or action for damages for death or personal injury caused by negligence, error, or omission in practice, or by the unauthorized rendering of professional services within 30 days to the board. So the impact to the board regularly receives reports of settlements, judgments, and arbitration awards over $3,000 of malpractice claims for licensees who possess professional liability insurance under BPC Section 801. These reports either come directly from the insurance companies or from the National Practitioner Databank. Therefore, there are fail-safes in place to obtain such reports. However, BPC Section 802 requires self-reporting from a licensee, a claimant, or the claimant's counsel when a practitioner is not insured. The board has rarely received such kind of reports in the past. There is no other resource for the board to rely upon that such information is sufficiently reported to the board. Raising the minimum fine may provide some additional incentive to comply with the provisions of BPC Section 802. This bill can be looked at as providing more public protection. The impacts to the board fiscally. Other sections of law within the same article identify that the failure to report is a public offense, which would not authorize the board to fine such parties for the violation other than a licensee. Violation of BPC Section 802 would be considered unprofessional conduct by the licensee and permits the board to take disciplinary action or issue a citation and fine. Since the fine assessment is set in law, it would be looked to as an authorizing statute, setting the board's authority to issue a fine at a minimum of $100 for unprofessional conduct for the failure to report qualifying items. By AB 810 increasing the minimum fine from $50 to $100, the board could recover slightly more in enforcement costs or receive more revenue through the issuance of citations and fines. The actual increase in revenue cannot be determined since there's no data demonstrating that the board has had a case involving a violation of BPC Section 802 in the past. Recommendation, the staff recommends a support position based on the fact that it does provide more incentive to comply with reporting these kinds of actions, and it provides more public protection. So we do have a recommended motion language here. So if a board member wants to make a motion, if they agree with this recommendation, it's here for anybody to speak up or have any questions. If the board chooses not to take a position on the bill, that's fine. I think we would maybe need some sort of consensus from the board members to indicate that.
Thank you.
Sure.
Supervisor, yes. So I just want to see if any board member like to have comments And then we probably would like to take a motion vote on this bill. Does any board member have any comments? No? Then I would like to make a motion. May I?
Certainly.
Thank you. So I motion that the Acupuncture Board take a support position on AB 810 Flora as introduced on February 16, 21, for the reasons discussed by members and staff and as reflected in the staff memo. Do I have a second?
I second.
Thank you, Member Kim. Oh, no, I'm sorry. Who second? Am I is Mr. Sorio?
Yeah, this is Kim. Yeah.
Okay, thank you. So do we take a roll call now or how we want to
Public
proceed?
comment?
Public
Public
comment.
comment first. Okay, let's do that. Moderator, would you please open up to the public comment?
All right, this is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click that Q&A icon at the bottom right-hand corner of your WebEx screen. I'll go ahead and pause a moment to allow the public time to access the Q&A panel and submit their requests. All right, seeing none, would you like me to close that Q&A panel?
Yes, please. Thank
All
you.
right, the Q&A panel is now closed.
So shall we take a roll call, Mr. Brookman?
I am ready. When I call your name, please let me know whether you're going to vote yes, no, or abstain.
Abstain.
Non-voting. Dr. Mateki,
Yes.
Kitman Chan,
Yes.
Yongping Chen.
Yes.
Mr. Harabini is not with us today. Francisco Kim,
Yes.
Shudong Li,
Yes.
Ruben Osorio.
Yes.
So I show a vote of 6 votes in favor, none opposed. The motion passes, Madam President.
Thank you, Mr. Brookman. Ms. Brothers, would you please
Yes,
continue?
thank you.
Sure. Thank you.
So moving on to AB 1026, business licenses, veterans, authored by Smith. This is another military-related bill that we're seeing. It hasn't been amended since it was introduced in February. It was held under submission by the Assembly Committee on Appropriations, so it's looking like this may not move this year. The summary of the bill, it would require DCA and any board within the department to grant a 50% fee reduction for an initial license to an applicant who provides satisfactory evidence as defined. The applicant has served as an active duty member of the United States Armed Forces or the California National Guard and was honorably discharged. This bill would authorize a board to adopt regulations necessary to administer these provisions. So this bill is similar to AB 1386 in its approach. It does provide more ease and convenience for military families, specifically veterans, if relocations were to occur. The board receives very few license applications from the military community. And I think it's basically the same statistics that we provided in AB 1386, the same volume of applications. So the impact to the board is not estimated to be significant. But this kind of legislation does again set a precedent for other communities to seek reduction in licensing fees. The board is special funded by its licensing fees, so the preservation of its fees is necessary to support and sustain the functions of the board. The specific fiscal impact of this bill just getting into that, based upon the board's history of low applicants affected by this bill, the board expects a revenue loss of approximately $2,450 annually if the provisions of AB 1026 are enacted into law. The board uses Connect and CAS as its database systems, so both programs would need to be updated to record when an applicant qualifies for an initial fee reduction under BPC section 115.4. This will allow for easy statistical reporting on this in the future. The exact IT impact related to AB 1026 is undetermined at this time. Staff also estimates that regulations would need to be passed to incorporate the information and instructions related to the reduction of initial license fees for military, actually it's for veterans, through the board's initial license application. At this time, staff is recommending a watch position just based on the fact that it's a 50% reduction, so it's a lower estimated revenue loss. And so if the board agrees with that, then a motion does not need to be taken. So I will leave it open to see if any board members would like to take a different position other than watch. And if I don't hear anything, then I can assume that a watch position is desired.
I agree on staff's position recommendation.
Okay, thank you. Okay. Sounding like nobody has any issue with that, so staff will go ahead and take, or excuse me, continue to watch this bill. Moving on to AB 1273, entitled Interagency Advisory Committee on Apprenticeship, the Director of Consumer Affairs and the State Public Health Officer, authored by Rodriguez. It was amended on March 22nd. It was referred to Senate Committees on Labor, Public Employment, and Retirement and Health. Current law, just for context, this is important to know that Earn and Learn is defined as programs that combine applied learning in a workplace setting with compensation, allowing workers or students to gain work experience and secure a wage as they develop skills and competencies directly relevant to the occupation or career for which they are preparing, and programs that bring together classroom instruction with on-the-job training to combine both formal instruction and actual paid work experience. So this more relates to the board's tutorial programs and possibly the clinical aspect of training programs. This bill would amend the Business and Professions Code and Health and Safety Code with respect to so-called Earn and Learn programs. It would also amend the Labor Code to add the Director of Consumer Affairs and the Public Health Officer to the Interagency Advisory Committee on Apprenticeship. The bill seeks to remove barriers to Earn and Learn programs, which are a combination of work experience and education to permit a student to earn a wage as they are learning. Examples of Earn and Learn programs include apprenticeships, internships, and other programs described in Labor Code Section 14005. The impact to the board. DCA boards would be prohibited from approving or denying an accreditation program that prohibits Earn and Learn programs. It would be required to use licensing and certification standards that authorize Earn and Learn programs. The Department of Public Health would face similar constraints about Earn and Learn programs when licensing or certifying health facilities. The board allows for Earn and Learn programs with the tutorial program pathway to licensure and will be able to comply with the bill. The board may need to implement regulations to ensure compliance with the bill, and the estimated cost of implementing those regulations would be the primary fiscal impact of the bill. But being that the board is already in compliance with the provisions of the bill and that it allows for these Earn and Learn programs, there isn't a huge impact to the board. And that is why staff is recommending a watch position on this bill. So again, if I don't hear anybody, having a different position on this bill, then staff will just go ahead and keep an eye on it. Also, if you have any questions, go ahead and let me know.
Yeah, I think we need to watch on this bill because I think it'll require a lot of faith from the stakeholders. So yeah, I would recommend. I mean, I would follow the recommendation of the staff.
Okay, thank you, Member Kim. Okay, so we'll definitely keep an eye on this one. Moving on to AB 1468, prior authorization, authored by Cunningham. This was amended April 29th. It was held under submission by Assembly Committee on Appropriations. So this bill would amend sections of the Insurance Code and the Health and Safety Code concerning automated systems that make care decisions involving, among other fields, acupuncture and traditional medicine. While the board and its obligations would not be affected by the passage of this bill, as written, the bill certainly would affect members of the profession who seek insurance coverage for their services, which is why we wanted to bring it to the board's attention. The bill was approved as amended by Assembly Health on April 27th. The amendments replaced all instances of the phrase Asian medicine with acupuncture and traditional medicine. The expressed intent of the legislation is to address practices that, intentionally or not, limit the availability of treatments including chiropractic services, physical therapy, occupational therapy, acupuncture and traditional medicine, speech-language pathology, and auditory therapies. These limitations mean that these treatments have been authorized at levels significantly below what is authorized in patients' evidence of coverage documents. The legislation would require any health service plan to limit who can deny or modify requests for authorization of healthcare services for reasons of medical necessity. Such decisions must be made by a licensed physician or a licensed healthcare professional competent to evaluate the specific clinical issues involved in the requested healthcare services. Additionally, if an automated prior authorization system is implemented by a healthcare service plan or an insurer, it shall use evidence-based clinical guidelines to program that system. The algorithms and related research and references shall be made available for download on the plan or insurer's website. Such an automated system shall ensure that any decisions to deny or modify requests for authorization of healthcare services for reasons of medical necessity are made by a licensed physician or licensed healthcare professional competent to evaluate the specific clinical issues involved. The impact of AB 1468 would be limited to the provision of medical services and reimbursement by insurance and/or managed care companies. As such, it does not affect the operations of the board, nor does it change the obligations of the board. And because of this, there is no fiscal impact that the board or that staff has estimated. Being that there's not a great impact to the board, staff has recommended that we just keep an eye on it and watch the bill. So I will leave it open for any questions. And if anybody has anything to say or has a different position, please voice that.
I think this one has a lot of it's got to do with the health plan administration policy, and due to this pandemic situation, a lot of health plans they just detour this process for like formal authorization. So I think we want to watch on this bill. There's a lot of things to discuss in terms of pandemic situation in the healthcare industry.
Okay, thank you, Member Kim. So we'll staff will keep an eye on this bill and continue to watch it. Moving to SB 607, Professions and Vocations, authored by Roth. This was amended on May 20th. It's in Senate floor process. This bill would require a board to waive all fees associated with the application and initial license for an applicant who meets these expedited licensing requirements. The only section of SB 607 that affects the board is the proposed amendments to Business and Professions Code Section 115.5. These provisions, again, are very similar to those of AB 1386. So again, another bill related to the licensing fees for military community. The remaining provisions of the bill affect the Dental Practice Act, Architects Practice Act, Contractor State License Law, and Private Security Services Act, so unrelated to the board. The impact, because the provisions are essentially identical to AB 1386, this is the exact same impacts. So I'm not going to reread them. Because the board already took an opposed position on AB 1386 based upon it having a revenue loss and setting a precedence of hardening licensing fees. Staff is recommending that the board take an opposed position on this bill as well. There is recommended motion language here. So if any board members have any questions or want to make the motion, please do so. Alternatively, if you just want to take a watch position, I would just need to know that, and we can just keep an eye on it, but would need to hear from some board members on that.
Thank you, Ms. Brothers. I would like to take a watch position on this.
Okay, sure. Does any other board members want to chime in, and do they agree with a watch position?
I would like to do the same. I think it would be the best thing we can do.
Okay, that was member Osorio.
Yes.
Okay.
So would you like to have a motion on that watch position, or you don't need it, Ms. Brothers?
Well, we were told by legal counsel it's not necessary for a watch position. I don't know if all of the board members have to agree. I mean, that would be essentially a vote, but I think being that nobody is making a motion to oppose, and we've heard from you and member Osorio to take a watch position, that would likely be enough. But if legal counsel wants to chime in if I'm incorrect, please do.
No, you're fine. It's correct. The board does not need to. Oh, this is Fred Chen, your legal counsel. If the board just wants to keep its watch position, it doesn't need to take any action at this point.
Okay. Okay, so I will go ahead and record that staff is watching this bill. And this is SB 607. Okay, thank you. Moving on to SB 741 on the very last bill, but it's kind of a doozy. It's entitled Criminal Records Relief, brought by Durazo. It was amended May 20th, and it's in Senate floor process. So I believe this bill is moving. I am going to go over the existing law. It's good to have an understanding of what is currently allowed in relation to what the bill is changing and adding to. So existing law authorizes a defendant who was sentenced to a county jail for the commission of a felony and who has met specified criteria to petition to withdraw their plea of guilty or nolo contender and enter a plea of not guilty after the completion of their sentence as specified. It also requires the court to dismiss the accusations or information against the defendant and release them from all penalties and disabilities resulting from the offense, except as specified. A person is eligible for arrest record relief if they were arrested on or after January 1st, 2021, and the arrest was for a misdemeanor, and the charge was dismissed or criminal proceedings have not been initiated within 1 year after the arrest, or the arrest was for a felony punishable in the county jail and criminal proceedings have not been initiated within 3 years after the date of their arrest. A person is eligible for automatic conviction record relief if on or after January 1st, 2021, they were sentenced to probation and completed it without revocation, or if they were convicted of an infraction or a misdemeanor and other criteria are met. So now SB 731 is doing the following. It's amending the law to provide that a person is eligible for arrest record relief if the arrest occurred on or after January 1st, 2021, and the arrest was for a felony, provided that criminal proceedings have not been initiated and at least 3 calendar years have elapsed since the date of arrest and no conviction occurred or there was an acquittal from the charges. It amends the law to provide that a person is eligible for arrest record relief if the arrest occurred on or after January 1st, 2021, and the arrest was for an offense punishable by imprisonment in state prison or county jail for 8 years or more. There's no indication that criminal proceedings have been initiated. At least 6 years have elapsed since the arrest and no conviction occurred or the person was acquitted. It allows a court to permit defendants who were convicted of any felony to, after a specified period after completion of the sentence, withdraw a plea of guilty or nolo contender and enter a not guilty plea, or allows the court to set aside a guilty verdict if the defendant is not under supervision or serving or charged for another offense. The court must then release the defendant from all penalties and disabilities. The exclusion of records of arrest and conviction that were granted relief from state summary criminal history information above does not apply to records for which the record holder is required to register as a sex offender, has an active record in the supervised release file, or if based on information available in the department's record, it appears the person is currently serving sentence, or if there is an indication of pending criminal charges. The exclusion of records also does not apply if the records are required to be disseminated by federal law. It makes conviction record relief available for a defendant convicted on or after January 1st, 2005 of a felony for which they did not complete probation without revocation if the defendant appears to have completed all terms of incarceration, probation, mandatory supervision, post-release supervision, and parole, and a period of 4 years has elapsed during which the defendant was not convicted of a new offense. Conviction record relief does not apply to a conviction of a serious felony defined in Subdivision C, Section 1192.7, a violent felony, or a felony offense requiring registration. It deletes the prohibition on granting relief if the person was incarcerated in the state prison. It provides, in addition, that relief granted does not release the defendant from the terms and conditions of any unexpired criminal protective orders. The most recent amendments to the bill on May 20th excluded serious violent and sex felonies from automatic relief, limited retroactivity to January 1st, 2005 for conviction record relief, delayed automatic relief for 4 years where there is supervision violation or a new felony conviction, and it removed the restriction on the access of cleared records. So there is quite a bit of impact that this bill would have, so I want to detail that. Under current law, defendants with infractions and misdemeanors who meet the specified criteria are eligible for automatic conviction record relief. Under this bill, the automatic conviction record relief is expanded to all felony convictions, excluding serious or violent felonies or felonies requiring sex offender registration. This means the records of these expunged convictions are sealed. Further, all of these convictions will not appear on the applicant's criminal history record the board receives from the Department of Justice when there's a fingerprint background check. So this is already the case for applicants who have misdemeanors and infractions that were automatically set aside or dismissed. And now it will apply to felonies. The board requires that all applicants be fingerprinted to perform a background check. The information available to board staff is limited to the criminal history information that is released on the state and federal summary. Therefore, if the arrest or conviction information that was granted relief does not show up on the applicant's criminal history record, the board is essentially blind to what occurred in their past. Currently, it is difficult to ascertain how many licensed applicants the board has evaluated who meet the criteria set by the courts to have a felony conviction expunged or charges and arrests set aside. The majority of conviction staff evaluates for applicants are misdemeanors, which are already withheld from disclosure if they meet the criteria for automatic arrest relief and conviction expungement. It is estimated the board receives a low volume of felony convictions to investigate on criminal history records of applicants. This would mean SB 731 would not have a substantial impact on the board. However, anytime the board does not have access to an applicant's record to determine pattern of behavior and crimes, moral character, and fitness for licensure, there is a concern for compromised public protection. Another note of concern is that BPC Section 480C, which is the board's authority to deny licenses, specifically prohibits the board from denying license on the basis of a conviction dismissed under Penal Code Section 1203.425. Therefore, even if the board were to somehow find out about a prior felony conviction that was dismissed, the board would not have authority to issue a denial of license for this conviction. This bill does not promote public protection to the extent it reduces the board's access to information about criminal convictions and impacts the board's ability to exercise its discretion to deny, discipline, or revoke a license based on an applicant's criminal history. This bill does provide greater opportunity for applicants who have arrests or convictions that do not affect their ability to provide safe services if they were to be licensed. There is quite a bit of fiscal impact related to this, more so that we would see to enforcement costs if they were to repeat their convictions or be a repeat offender. So let me get into that. If the board has access to an applicant's criminal history record and affected felony convictions are disclosed, staff can make a determination with greater certainty on one's fitness for licensure. If the applicant's record is considered substantially related, the applicant can be issued a denial of licensure. At this point, the applicant may request a hearing to contest the denial, but the burden of establishing if they qualify for licensure and are rehabilitated falls on the applicant. In addition, some of the time, applicants will not request a hearing, so the board incurs no attorney general costs. Investigation costs are generally low, as they're usually limited to the cost of procuring the criminal records and statements from the applicant. Under SB 731, if a license is issued to an applicant with multiple crimes, including felonies that have all been expunged, the likelihood for recidivism is increased. This means a conviction could occur after licensure, which makes it more difficult for the board to seek discipline or revocation of license. The burden of proof is shifted to the board for establishing a case that a licensee is not safe to practice. The enforcement costs are generally higher for investigations of licensees. The attorney general costs will likely be higher given the increased likelihood of going to hearing, and the hearing may draw out longer, thereby increasing costs for the board. The impact of SB 731 may be delayed in its effects on the board's enforcement costs when an applicant is issued a license without the relevant criminal history information, and they reoffend, causing the board to incur more costs to sufficiently protect the public. At this time, the increased enforcement costs are unquantifiable. The board, or excuse me, staff is recommending a watch position on this. It's a trend that we are seeing these types of bills come through the legislature, and they are often signed into law. So we saw it with AB 2138, and we saw it with a teen bill, I believe 2 years ago, that put it in place for misdemeanors to be automatically dismissed or set aside. So now this is kind of part 3 here with SB 731 now including felonies. So just thought staff could keep an eye on this. The department is definitely keeping an eye on this bill. So are there any questions on this bill? Does the board agree with the watch recommendation?
I remember the reinforcement staff told us that the Acupuncture board the discipline or the complaint report coincides with other similar board reports. So maybe we can watch and see what other boards are doing, because we are a relatively small board. So maybe other boards will have to come up with a conclusion or the position. Then maybe we can follow and consider at that time. So I would go with the watch position, like that recommendation.
Okay. Yeah, that's a good point. At our August meeting, we can always update and see what other boards, what positions they're taking. And you always have the opportunity to change the position. So it sounds like we're going to staff is going to keep an eye on this bill, and we'll go ahead and, report on it in August. So that concludes my report. I think we probably can open it up to public comment, but I will send it over to President Mateki to facilitate that.
Thank you very much, Ms. Brothers. What a tremendous work you and your team has done. Really, really appreciate it. So now I would like to open to the public comments, but prior to that, if any board member have any comment on any of the bills discussed by Ms. Brothers, please speak up. Otherwise, I would open up to the public. Here now? Okay. So we will open up to the public comments. DCA moderator, please help facilitate. Thank you.
This is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click that Q&A icon at the bottom right-hand corner of your WebEx screen. All right, it looks like we do have a couple individuals who have requested public comment. We'll start with our first individual identified as David Quackenbush. You'll be given 3 minutes to speak in a 30-second warning. I am unmuting your microphone now.
Thank you for that. Good afternoon. This is David Quackenbush for CSOMA, the sponsors of Assembly Bill 918. As reported, 918 has become a 2-year bill. And in the interim leading up to next year, we are having conversations with folks who had concerns about the bills to amend and potentially revise the bill that would reflect some of the concerns that were brought during this last meeting. So I just wanted to make sure the board was aware that the bill is a 2-year bill, but our conversations continue to improve the bill. Thank you.
All right, this is the moderator, and our next individual who has requested public comment is identified as Neil Miller. Neil, you'll be given 3 minutes to speak in a 30-second warning. I am unmuting your microphone now.
Christine Brothers, Neil Miller from CalAtma. Christine, you did an absolutely fabulous job, better and better every time. I couldn't be more happy to be associated with you and your team for the presentation that you made. It was extremely clear in the documents, and I really want to thank you on behalf of our association, anybody else who got to see this. We agree with just about everything. The AB 1468, we are in support of. I understand that the board took a watch position. It doesn't really affect you, but I do understand that. We do agree with the staff on AB 607 to oppose as opposed to take a watch position on that. I think it's pretty spectacular to imagine that we would be able to make public comment on 17 bills in 3 minutes. That having been said, I'll let every other comment go, other than about AB 918. AB 918 was reported in Acupuncture today that there were amendments. We contacted the author of the bill, and there are no amendments at this time. We did have a meeting with all acupuncture associations in California that were opposed to this bill, and we are still opposed to this bill. And we are working with all the different associations to continue our opposition to this bill next year until such time that would be even appropriate to discuss it after the occupational analysis of both the Acupuncture Board and the NCCOM are completed. So we're putting a lot of, we did put some effort into meeting with all of the stakeholders, and there was no Nobody else who changed their position. Every association in the state that we were able to contact did show up, and they were all firmly in opposition. And we'll see if there's any amendments between now and January that would sway us. Thank you again, Christine. That was really, really spectacular presentation, and that's the end of my presentation. Thank you.
All right, this is the moderator, and it appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, please. Thank you,
All right.
moderator. So I just wanted to ask Ms. Brothers, I know you've been have the whole discussion for an hour. Would you like to proceed on the agenda item 12, or would you like we have a break now? Because I know you've been working very hard. I just wanted to ask you if you wanted to proceed.
Oh, thanks for checking in. Actually, David is going to take that item from my understanding. So I think I'm done. And I'm sure he's okay to start.
Okay, thank you. I think it's a 3:51 right now. Maybe we will take another break. Bear with us. So probably we return. It's a 3:51. So shall we come back at 4 o'clock? Thank you, everyone, for being patient with us. Does all the board member back?
Madam President, I could take the roll if you'd like.
Do we maybe ask Mr. Boudia, do we need to do the roll call? Any bills need to be, or any motions?
Given what's left this afternoon, I don't anticipate any votes.
But we would have to do a roll call just because we took a break. Let me just double check with DCA moderator if we're recording.
Yes, thank you.
Yes, this is the moderator. We are still recording.
Thank you very much.
Thank you.
We are ready to move forward.
I can proceed with the roll.
Sure. Thank you, Mr. Brooklyn.
All right. Please let me know when you're here, if you are here when I call your name. Dr. Mateki?
Yes, present.
Kitman Chan?
Present.
Dr. Chen?
Yes, here.
Mr. Harabedian is still absent. Francisco Kim?
Present.
Thank you. Shudong Lee?
Present.
Ruben Osorio?
I'm here.
Thank you, sir. Madam President, I show 6 members here. We have a quorum and we can proceed.
Thank you, Mr. Brugman. So let's move to the agenda item 12, regulations update. And I believe Mr. Brugman is your
Yes, I will handle the report here. Thank you. So I'm just going to go over the current status of the regulatory packages that the board is working on. And the first one is the regulatory package to implement AB 2138. This addresses the board's ability to deny an application or to revoke or suspend a license based on a criminal conviction. And so the new regulations identify how we can consider an applicant's efforts towards rehabilitation, as well as whether or not the criminal conviction that's at issue was substantially related to the practice of acupuncture in this particular case. So the current status of this package is that in April, it was submitted to the Office of Administrative Law for review. And at this point, that's where the package stands. Does anyone have any questions on this first package before I proceed?
Go ahead.
Of course. The next package addresses SB 1441, which would implement uniform standards across the Department of Consumer Affairs about substance abusing licensees, and also then update of our disciplinary guidelines. The board at its December 2020 meeting approved modified text and updates to the guidelines to align them with AB 2138, which I just addressed in the previous package. The initial draft of the initial statement of reasons is currently with Legal Affairs for review, and we anticipate being able to submit or to file that package in July of this year. Does anyone have any questions about item number 2 before we proceed? Okay. Item 3, SB 1448, related to disclosure of probation status to patients. This has been incorporated essentially with the package for number 2, but these specific changes are meant to require licensees on probation that to an order that was made on or after July 1st of 2019 to disclose that status to a patient or their guardian or healthcare surrogate prior to that patient's first visit. And as with the previous package, that initial draft of the initial statement of reasons is under review with legal, and we anticipate filing everything together in July of this year. Any questions about package 3? Okay. Package number 4 concerns aligning curriculum standards and approved regulations with SB 1246, and this was the main shift from approving schools to approving curriculums for training and education programs. And we approved some additional regulatory language at the March meeting, and are presently developing that regulatory package within the board staff, and hope to be able to file that later this year. Does anyone have any questions about package number 4? Okay, package 5 concerns the application process, criteria, and procedures for approval of a credential evaluation service. This would allow us to approve these kinds of services to evaluate the foreign education of applicants for licensure. Previously, the board has had no way to evaluate the non-U.S. education of licensed applicants. So at the March meeting, we'd approved some regulatory language for this particular package, and additional language we had anticipated bringing it before the board during this meeting, but unfortunately we're going to have to delay that, and we may be able to do that in the August meeting, but we won't know that. We'll know more about that as we develop that agenda for the August meeting. Does anyone have questions about the application process package? The next package concerns the board fee schedule. This is a Section 100 process. It goes through a slightly streamlined administrative process. And so we were able to go through this process a little bit faster, and the Office of Administrative Law gave final approval on the new fees on May 24th of this year. So the fees are effective as of that date. Any questions about the fee package regulations? So the retirement license status package. We have a board previously approved regulatory language in August 2019. We're continuing to develop the regulatory package and hope to be able to file that later this year. Any questions about the retirement status regulatory package? So at the March meeting, the board approved working on a regulatory package for continuing education requirements, specifically for education in law and ethics for licensees. And we're working on developing that package with staff at this time. And the same is the situation for the other package that we approved at the March meeting, which involved standards of practice for telehealth services. Staff is currently working on developing the regulatory package for that, and we'll be able to update you as things progress. Do any board members have any questions about any of the regulatory packages I briefly summarized for you?
Is there a timeline for that, or just it's kind of just develop that?
For the telehealth and the continuing education requirements, ideally we would like to have them submitted by the end of this year, but we don't have a more specific date at this time. Any other board member questions?
I don't have it. I think you did a great job, Mr. David Brugman.
Thank you, Madam President. I think we will still need to open this for public comment.
Yes. DCA moderator, would you please help to facilitate the public comment? Thank you.
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click that Q&A icon at the bottom right-hand corner of your WebEx screen. I'll go ahead and pause a moment to allow the public time to access the Q&A panel and submit their requests. And it looks like we do have one request from Neil Miller. Neil, you'll be given 3 minutes to speak and a 30-second warning. I am unmuting your microphone now.
Thank you. Neil Miller from CalAtma. Item number 4, where we talk about the quality assurance, aligning curriculum standards and approved related regulations with standard. When you go through this, just be aware that the ACOM standards are much less than our current curriculum hour standard in California. And again, I reference back to the curriculum competency hearings, and I do hope the board, especially the public members, will take the time to read those standards so that you see that the standard in California is higher than the ACOM curriculum standards, and I think that we really need to address that. Also on numbers 8 and 9 in relationship to the courses that were approved last time, law ethics courses. We're very excited about this, and as well as the telehealth standards. But where it comes to the law and ethics courses, we would like to work with the staff or with the board to work on this, and we would really like to get the parameters of what you're looking for and what we think as a professional organization would be best included here to protect the consumer at the highest level. So we would like to have some input here, other than coming to a meeting, listening to a report, and having 3 minutes without any real interaction. So we hope that going forward, we'll be able to improve upon these regulatory changes by including the stakeholders, and CalAtma would like to sit at the table and be a part of that discussion. Thank you.
All right, this is the moderator, and our next individual who has requested public comment, identified as Dylan Stan. Dylan, you'll be given 3 minutes to speak and a 30-second warning. I'm unmuting your microphone now.
Hi, this is Dylan Stan from Net of Knowledge. I actually, this is a question. I'm not quite sure if you're allowed to answer, but this is not so much a comment, but more a question. I noticed that in the Section 100, the regulations that were passed through, specifically the continuing education fees, the course approval fees weren't included there, but the provider application and renewals were. So I'm just wondering why that would be and what are the implications of that, if you don't mind. Thank you.
All right, this is the moderator. We will move on to our next individual who has requested public comment. Individual identified as Steve Liu. You'll be given 3 minutes to speak and a 30-second warning. I am unmuting your microphone now.
Okay, thank you. This is Steve Liu. I'm the chair of CAUA, California Acupuncturist United Association. I would like to just to give some idea of the we've been conducting with continuing education over Zoom, which is doing very well. We have more acupuncturists as members to join these continuing educations, and throughout this web system, we were able to invite overseas expert or professor to give lectures. So we've been seeing increasing of the people to join this webinar continuing educations, which is good for all members to get more acknowledge of this practice, and certainly to obtain the adequate continuing educations. Thank you.
All right, this is the moderator, and that appears to be our last individual who has requested public comment. Would you like me to close that Q&A panel?
Yes, please. Thank you.
All right, the Q&A panel is now closed.
Thank you. So, Mr. Boudia, do you want to have anything to add, or any board members would like to have anything to add on this item before we close it?
I can address any questions the board has, if there are any questions.
Any questions from the board members?
So the public comment in this process, including the board comment, only applies to this board meeting session, right? Meaning, when this thing is, all this thing is being developed, there's no other chance for the public or other board members to make a comment or comment on these items besides the board meeting. That was my question.
I just want to make a thank you for asking. I just thought maybe our EO, Mr. Boudia, have anything to add. But sure, if the board member have any comments or would like to make before we move on to the next item.
To address Member Kim's question, the regulatory process is all about the involvement of all stakeholders, such that there is the opportunity to comment on language as it's developed by staff and brought before the board. And once the board makes a motion to approve, then there's again an option for public comment. Once that is approved, is set into the regulatory process, where there's a 45-day comment period for the public and stakeholders to write in comments or present them at the hearing at the end of that time. So there's definitely stakeholder involvement throughout the entire regulatory process. To distinguish that from the Section 100 process, which was shared earlier in regards to AB 3330, which had our fee schedule, the Schedule 100 allows for, Section 100 allows for technical non-substantive changes. And the reason why our fees applied here is because it was changed in statute. So therefore, what the Section 100 allowed for this to happen was to take the fees as established in statute and replace the fees that were set previously in regulation, update them so that they are in alignment with the fees that supersede that, that being statute.
Thank you for clarification. Yeah.
Certainly.
Thank you, Mr. Bodia, for the clarification. Yes. So if no questions, let's move to the next agenda item, number 13, Consumer and Professional Associations Report. Mr. Bodia, would you like to facilitate on this one, please?
Of course, Madam President. We can go ahead and open it up if the members of the association that are joining us on this meeting would like to go ahead and just use the same public comment method that we've been using. Moderator, if you could go ahead and post that up and just note that you would like to make a comment, and then you can introduce yourself, your organization, and your update. Please take 3 minutes and you'll receive a 30-second warning. Thank you.
All right, this is the moderator, and I have opened up the Q&A feature for the association updates. So if you would like to make a comment, please type "I would like to make a comment" in the Q&A feature, and I will unmute your microphone. You'll be given 3 minutes to give your update. Thank you. All right, and it looks like we do have one individual who has requested to give an update. Individual identified as Nell. Nell, I'll be unmuting your microphone now.
Great. Thank you so much for the time. This is Nell Smersina, CSOMA. David Quackenbush already gave our update on 9/18, but I did want to just go over a few things. Our association is continuing to see growth. We've had about 40% growth since the start of the COVID shutdowns. We recently had a school sign up all of their students to be CSOMA members, which we're really excited about. We're seeing increased student engagement, particularly around advocacy work. We have continued our monthly CE series, California CEs, as a member benefit, and we're planning to continue that through the rest of the year to continue to support members who have been very much affected with everything going on the last year and a half. And we will be having our town hall in August, a few weeks before the board meeting. So more updates on that to come. Thank you so much.
All right, we'll move on to our next individual, Steve Liu. I'll be unmuting your microphone now.
Okay, thank you. Thank you, host. Again, this is Steve Liu, chair of CAUA. I would like just to updating our continuation program through Zoom webinar system, which is doing very well. Through this system, we were able to invite world-renowned professor or expertise to give more deeper of the Chinese medicine, acupuncture, to enhance our members' practice, and also to be able to getting more different scenario or different skill and knowledge from a different country of the world. So it is being getting more and more popular with all members and acupuncturists. We are increasing tremendously members, not just only in California, also from other state, other country, such like Hong Kong, Taiwan. So we like this system very much. So we will continue to use this system, even though we were able to back to live seminar. We will conduct both program to provide to all our members. And secondly, I would like to give some purpose regards to the pandemic, so-called COVID-19. Because I'm chair of the association, so I witness, includes myself, by using the Chinese herbs to help the COVID patients for their recovery. We are seeing a very, very good result. As long as to helping people who recover from COVID-19, even though they are tested negative, but still have post
30
symptoms.
seconds.
Thank you. By using acupuncture and herbs are being very helpful, as well as to help him for the immunity side symptoms, such as cardiovascular or fever or neural system, such as joint pain. With Chinese medicine and acupuncture also is very helpful. So I would like to propose to the board, maybe we should set up some type of protocol, so to give some information idea to acupuncture school and to all the members in this area, so can be fortified to help all these people. Thank you.
All right, this is the moderator. We will move on to our next individual who has requested to give an update. Neil Miller, I will be unmuting your microphone now.
Neil Miller from CalAtma. I'm pleased to state that CalAtma's membership is still the largest in California with over 500 members. We have launched our student membership outreach program at several of the schools. We've signed up the students from several schools, and we'll be having in-person town hall meetings throughout the state. We'll be announcing our summer tour soon. Our monthly newsletter is now distributed to close to 3,000 practitioners in California. So we're really getting the word out, and we're having that translated to our ESL associations with some of our members, trying to bridge that gap so that we're all speaking in the same language. We continue to provide high quality CEs for free every month, as well as other high quality speakers at a reasonable discounted price. Our stakeholders are meeting with associations in California. We started talking about AB 918, but we realized that we have so much more in common that we're working together on our legislative package for next year. CalAtma is committed to having an MUA, or a mutual understanding agreement, with the different associations, so that we are on the same page with legislation and we don't appear as foolish as we did this year, as being divided amongst one another. We are having our annual meeting in October, and that will be on Zoom. We have 3 bills for next year that we'll be discussing with the different groups on Asian massage, lasers, and therapeutic bleeding, as well as discussions on dry needling, which we expect to be next year. So we're discussing the issue amongst ourselves and the stakeholders on dry needling, and we've actually had several conversations with the physical therapist trying to work out and discuss how far apart we are and working together. We've been working with the physical therapist on several other bills that meet both of our needs. October 24th is the Acupuncture Traditional Medicine Day, celebrated nationally. We will have a celebration in San Diego live that we will be sponsoring. We are now just
30
finishing up
seconds.
getting the restaurant. We will be doing one in the Bay Area and one in LA County with other associations. And lastly, we are announcing our spring seminar. We will be doing a 2-day seminar every year starting next year. Our symposium will be in Napa. We'll be featuring Chinese, Japanese, and Korean styles on one day, and on the other day, an integrated acupuncture program featuring California trained practitioners and really looking at California schools and the level of high quality that we present there. Got it in 3 minutes. Thank you very much. Today was a great meeting to the board and all the participants.
All right, this is the moderator, and it appears that is our last individual who has requested to provide an update. Would you like me to close that Q&A panel?
Yes, please. Thank
All
you.
right.
All
Madam
right.
President, that concludes
Yes.
our Consumer Professional Association report. And
Thank you.
item 14, as you noted earlier, has been tabled due to the cancellation of the committee meeting, which leads us to item 15.
Thank you very much, Mr. Bodia. Okay, now let's move on to our agenda item number 15. Board members, what would you like to see at the future agenda? Please unmute your phone.
This is Yongping Chen. Thank you for allowing me to give my word. So I would like to see next meeting we will have education committee to proceed the same agenda. Thank you.
Thank you, Dr. Chen. What your comment is regarding the Education Research Committee will be on for August, correct?
That was my capture as well, Madam President.
Okay, good. All right, thank you. Any other board members would like to see for the future agenda?
Yeah. So for as a member of Education and Research Committee, all these agendas will be discussed in the August, as I understand. But if we could maybe have some input from other public members, I mean from the public, well, how can we accommodate those comments in the meantime? It'll be 2-month period, but I'll see that. First of all, I think we need to have some kind of a stakeholders meeting to discuss on these agendas, like to set the standards of this profession, because I see some of the associations, they want to go ahead with the one bill, and the others are opposing, and it's not going to happen, and they still want to continue. I don't think it's desirable for this profession. So maybe I propose to have a stakeholders meeting so that we can have some kind of a consensus on this profession's future agenda, and even before or in between the board meetings. so that we can have some consensus. That's my comment.
Thank you, Member Kim. Are there any other board members who'd like to see any future agenda items?
One more thing. I think we can discuss on curriculum review. I remember that this curriculum review will be due on next year. Is that is that right?
I can step in here. Member Kim, yes, the plan is the strategic plan item is to review the curriculum to establish whether or not it is sufficient for entry-level practice of acupuncture within this strategic plan year, that being 2018 through 2022. So the hope would be that we can start reviewing the curriculum at these committee meetings in short chunks. This is a large curriculum, and so the committee meeting that was scheduled for today and has been tabled for or moved to August meeting will be starting that review in the herbal section for the herbal education portion and the exercise therapy portion of the curriculum.
Okay, I would propose an agenda that we can look up on clinical science and other Western medicine parts curriculum so that we can contract with other healthcare professions. The reason is I've been researching on some of the employment of the licensees, and then they are talking about the they can see the patients inside the hospital, but they are not recognized. Not because they don't have the NCCOM, but because they are not concurrent with all this Western medicine or clinical science.
This is Fred Chen, DCA Legal. So is the request for the agenda item that this item discussion be placed in a future committee meeting?
Yeah.
Okay, thank you.
Yeah.
My capture was that these would clinical sciences and basic sciences, clinical medicine and basic sciences would be the two topics requested for review after the herbal education and the exercise therapy. Did I capture that correctly?
Yes. Thank you.
Thank you, Member Kim.
Thank you, Member Kim. Thank you, Ligo and Mr. Boudia. So any other board members would like to see the future items on the agenda? No? Okay. Now would like to open up to the public. So DCA moderator, could you please facilitate the public comment on this?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click that Q&A icon at the bottom right-hand corner of your WebEx screen. I'll go ahead and pause a moment to allow the public time to access the Q&A panel and submit their requests. This is the moderator. It looks like we do have one request from Neil Miller. Neil, you'll be given 3 minutes to speak and a 30-second warning. I'm unmuting your microphone now.
Yeah, I would like to echo Neil Miller from CalAtma. I would like to echo Francisco Kim's additions for future agenda item discussions on science and integrative medicine, drug-herb interaction. And I would hope that rather than just do the exercise and herb section next month at the next meeting, that we could actually add in another section, because it was supposed to be done today. And if we delay, we're just going to delay a little bit further. So maybe we could include it in next month's meeting. The curriculum discussions, I would hope that you would have those discussions, and part of that discussion would be the education committee reviewing the curriculum competencies that were discussed in previous boards, because that information is equally as relevant today as it was then. And at that time, the schools were opposed and the profession had a different position. And that takes me to my next topic for future agenda items, which has to do with the doctoral programs. You can spend $10,000 and take a course online and you can be called yourself a doctor. And somebody with 30, 35 years of experience isn't a doctor. And in the eyes of the consumer, this is quite confusing. That somebody who has all of the experience and a hell of a whole lot more knowledge than somebody who just got out of school. So what I'm seeing are students getting out of school today and they're a doctor. Nothing wrong with that, but you're leaving people who have tremendous experience and continuing education for 20, 30 years that far exceeds that person. So I would like to see on the agenda a discussion of the doctoral programs and what is in the best interest of California consumers, not in the best interest of a national doctoral program. That's where we have a problem. Let's discuss what's best for California and set California standards. Thank you.
All right, this is the moderator, and it looks like there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, please. Thank you.
All right.
Now let's move on to our final agenda for today. Adjourn of the day 1. Thank you everyone, the public and the stakeholders, for your participation in today's meeting. Thank you to the DCA moderator and our IT team and for all your assistance. Also, thanks to our executive officer, your staff, and our legal counsel, board members for all your hard work and participations. Look forward to seeing you tomorrow at 9:30. Meeting adjourned at 4:41. Thank you.
All right.